rounding third and heading home, I am concerned that we are going to be voting this afternoon on the nomination of David Hamilton to be the Seventh Circuit Court of Appeals. I think Hamilton is without question a liberal activist judge. He believes judges do not simply interpret the Constitution of the United States, but that judges have the power to actually change the Constitution when deciding cases, stating that, and this is his quote, Mr. President, he says, part of our job as judges is to write a series of footnotes to the Constitution. Now, this is exactly what our founding fathers didn't want us to do. Judges are supposed to interpret what we do in this chamber. When he was nominated to be in the district court in 1994, the American Bar Association rated him as not qualified. I voted against him for a number of reasons back in 1994. Now, I don't very often agree with Vice President Biden, but I have to say this. Vice President Biden made a statement some time ago that I do agree with, and that is, if you are in the United States Senate and you have a judge that's coming up to be confirmed by the Senate, and if you oppose that judge when he comes up to be a federal judge, then later on, when he wants to become a circuit judge or even the judge of the United States Supreme Court, if you oppose him at a lower position, you have to oppose him at the next positions because the bar necessarily goes up as it goes up. So for that reason and many other reasons, I will be opposing him. I think it's important that in 2003, in a Woman's Choice versus Newman, Hamilton issued an injunction against an Indiana law that required abortion clinics to give women information about alternatives to abortions in the presence of a physician, nurse, or somebody else. Just to have that information, this is inconceivable to me, and that this could happen. And let's keep in mind also, this is the same judge that had a ruling. The speaker, perhaps the most infamous because of his 2005 decision while presiding over the case of Hendricks versus Bosma, in which he enjoined the Speaker of Indiana's House of Representatives from permitting sectarian prayers to be offered as a part of that body's official proceedings, meaning that the chaplain or whomever opened the proceedings with a prayer could not invoke the name of Jesus Christ. In his conclusion, Hamilton wrote, if the speaker chooses to continue any form of legislative prayer, he shall advise persons offering such a prayer that it must be non-sectarian, must not be used to proselytize or advance any one faith over another. Well, this is the first time and the only time I believe that this has happened in confirmation. This will be coming up for confirmation. I hope all of America will be aware of the fact that this is happening. Now,